All right. Hello, everybody. Let's go ahead and get started. I think maybe there's some people still coming in, but we'll go ahead and kick this thing off. Hopefully, you can all hear me all right. My name is Todd Moody, by way of introduction. I'm an attorney with the law firm of Brown Fortunato, and it's a pleasure for me to be speaking to you guys today. By way of background, our law firm is based in Texas, and we have a national healthcare practice. We have about 15 attorneys in our healthcare group who do lots of regulatory and corporate transactional work. We do things like defending people against investigations and just day-to-day kind of compliance issues. So we represent healthcare providers of all types, as well as manufacturers, distributors, and just about any other kind of healthcare related business so you can think of. Personally, my primary focus is on durable medical equipment and pharmacy, various businesses within those industries. But that's who I am, and that's a little bit about our law firm. Today's presentation is going to consist of what, in my mind, is an entry-level kind of primer overview of the main fraud, waste, and abuse laws that impact businesses in the healthcare industry. And most of these laws, with one exception at least, apply to all types of business. So they're not specific just to providers. They can apply to manufacturers, distributors, and they can apply to parties on both sides of an arrangement in the healthcare industry. So I know everybody is just thrilled to be listening to an attorney drone on about regulatory compliance issues for about an hour. So you're welcome in advance for this exciting opportunity that you get. But really, these issues are important for you all to have at least a baseline understanding of. You need to have some knowledge about this if you're working in a business that is healthcare related. Right now in the DME industry, we're living in a bit of a glass house. The DME industry, as we think of it today, is not very old. And you don't have to look back very far at all to when this industry was basically unregulated. It was the Wild West, and money was flowing freely, and life was good and easy for everybody. But that's not the case now. Today, there's regulation that is coming from all directions. There's federal laws, there's state laws, then there are agencies under the federal and state levels that have their own requirements. There's government contractors who are auditing not just claims for overpayments, but they look at other general regulatory compliance issues. So there are people looking at everything that healthcare companies do, and DME suppliers now are no exception to that. So with that being said, let's go ahead and get into the substance of my presentation. First, I'll give you a little roadmap. First, I'm going to provide an overview of what I think are the main laws and regulations that you need to be aware of. And following my overview of those laws, I'll go through some common arrangements that can implicate these laws. It's important for you to know that when I use the word implicate, I don't mean that those arrangements necessarily violate the law. All I mean when I say that they implicate the law is just that the arrangements contain elements or characteristics that could trigger those laws. And so they are types of arrangements that need to be analyzed under one or more of these laws. Most of the time when I'm reviewing arrangements for clients under these laws, I'm not dealing with black and white scenarios where I'm telling clients, okay, you've given me the facts of this either existing or proposed arrangement, and I know for positive sure that that is a violation of X statute. Normally, we're dealing with a spectrum of risk. We're looking at these things and saying, well, here are some characteristics of this arrangement that if the government was looking at it, might indicate that that there is some risk that this could be problematic. But then here are some other characteristics that cut in favor of it being okay, and that that reduce the risk that this would be harmful either to patients or to government programs. So that's another reason why it's important to be aware of these things, because most often you're not dealing with black and white situations. The first law that we'll get started with here is the big one that I think of, and that's the federal, or this slide has it titled the Medicare Anti-Kickback Statute. That slide is a little bit of a misnomer by saying Medicare, because this applies to all federal healthcare programs, not just Medicare. So this is the federal anti-kickback statute. And I tend to talk about this law so much and so often that sometimes I feel like I'm really an anti-kickback statute lawyer. If you look at the text of this slide, you'll see a big F word in it, that being felony. It's the fourth word there under the only bullet. This means that violations of the anti-kickback statute can carry criminal penalties. So that's why I call this the big one. Understanding it is very important because the penalties for its violation can be very serious. The anti-kickback statute, in its most basic form, says that a person cannot pay for referrals of patients covered by a federal healthcare program. So you can't pay Dr. Smith $100 per Medicare referral that Dr. Smith sends your way. Okay, that's the most obvious violation of the anti-kickback statute. And often it's blatant violations like that we see in the news or in Department of Justice press releases where people get in big trouble. But really, this law goes much farther than that. It has a much broader scope in terms of what it can actually apply to. So let's take a look at what it actually says. Look at the text of this slide that is on your screen, and we're gonna briefly go over these bolded terms and what they mean. So the kickback statute, it says that you can't offer, pay, solicit, or receive any remuneration to induce a person or entity to refer an individual for the furnishing or arranging for the furnishing of an item or service payable by a federal healthcare program. So let's take a couple of these bolded words here. It says that you can't give or receive essentially remuneration. What the heck does that word mean, remuneration? Remuneration really just means anything of value. Okay, it doesn't just mean paying or receiving cash money. It can be anything of value, whether that be cash or it could be something as simple as performing services for the other side of the transaction that that the other side would normally have to perform themselves. They would have to exert some effort or spend some money to do the things that you're doing for them. So that it can be anything of value that can trigger this. And the statute says that it applies to giving remuneration for either referrals or arranging for referrals. Or if you look down at the next bolded line, inducing someone to purchase or recommend the purchase of items. So it doesn't just apply to giving something of value to somebody who is a direct referral source. It can apply to a lot more than that. It can be giving something of value to somebody who then arranges for a physician or another referral source to send business your way. So it can be a little more indirect of an arrangement and still implicate the anti-kickback statute. But at the end of the day, the easiest way to think about it is the anti-kickback statute prohibits giving something of value in order to get more business that is covered by federal health care programs. And that can be Medicare, Medicaid, TRICARE, or other smaller, lesser known federal health care programs. So the next law that we'll touch upon here is the Beneficiary Inducement Statute. And the Beneficiary Inducement Statute, it imposes not criminal, but civil money penalties on somebody or any person really that gives, and there you see that word remuneration again, someone who gives anything of value to a Medicare or Medicaid patient. So this isn't like paying sales reps or other referral source. This has to do with giving something of value to a patient directly when you know that what you're giving the patient is likely to be an inducement or to influence them to choose you as their provider of covered products or services. Now, the Beneficiary Inducement Statute, it's related to the Anti-kickback statute. When you read it, there's some similar words, and when you think about it, they seem quite similar, and that's true. They are. There really is some actual overlap between these two laws, but they are different. Like I said, the Anti-kickback statute has a broader reach, and the Beneficiary Inducement Statute is a little bit more specific to your dealings with federal health care program patients directly. Now, we'll go over this a little bit more later, but there are exceptions to the rule. And this is true for the anti-kickback statute as well. But here we have a slide that talks about an important exception to the Beneficiary Inducement Statute. And when the government originally set forth the regulations that are related to the Beneficiary Inducement Statute, the government provided some commentary to those regulations. And in that commentary, the government said that this statute isn't meant to apply to things that are given away to patients when those things only have a nominal value or a very low value. So what does that mean? Well, what is nominal value? Well, it used to be for many years that the government interpreted nominal value to be anything that was worth $10 or less individually, and any combination of items worth $50 or more over the course of a single year. So in order to fit within that exception, you couldn't give somebody worth any single thing worth more than 10 bucks, and any combination of $10 or less items that were worth 50 bucks over the course of a year. But not too long ago, and for the first time, the government issued guidance increasing those limits. So now you can give single items worth up to $15, that's nominal value. And over the course of a year, a provider can give a patient up to $75 worth of those items under the nominal value exception. So that's an important exception. We'll talk about that more a little bit later. The nominal value exception, however, that's not the only exception to the beneficiary inducement statute and to giving away items or services to federally insured patients. When the Affordable Care Act was passed, it provided some exceptions to what might be considered prohibited remuneration under actually the anti-kickback statute. But I think that that the guidance that was issued under the Affordable Care Act about the anti-kickback statute actually also has a direct bearing on what's allowable under the beneficiary inducement statute as well. And the Affordable Care Act said that prohibited remuneration does not include items or services that pose a low risk of harm and that can promote access to care. So despite what the value of these things are, whether they fall into those $15 and $75 limits, if things aren't likely to harm the Medicare program, and they actually are promoting the patient to be able to get the care that the patient needs, then those things might be okay. So what's actually meant by promoting access to care or posing a low risk of harm? Well, promoting access of care, if something is going to promote access to care, it should take the form of something that actually removes a barrier to obtaining care, as opposed to something that more indirectly encourages people to get the care that they need. So as you can see here, the guidance has been issued that talks about removing either socioeconomic, educational, geographic, or mobility barriers. So the Office of Inspector General, which is the enforcement wing of CMS, they addressed some things that they were seeing that providers were using that they thought would promote access to care. And they gave some examples, and two of those things were, one, providers may have been offering up free childcare during appointments. And another one was they were seeing providers give things like free movie tickets to people who would actually show up for their appointments. And when the OIG issued its guides about these things, it said that things like providing care, child care during an appointment, those are okay. Those actually remove a barrier to someone getting the care that they need and promote access to care in the way that the government thinks is appropriate. Whereas something like giving movie tickets to induce someone to show up to their appointments, that's not what the government is talking about here. So while it could indirectly promote someone to get the care they need, that's not what the government is talking about. And it doesn't actually operate to remove a barrier to obtaining care. And something poses a low risk of harm to Medicare and Medicaid if it's unlikely to, say, cause a prescriber or a doctor to make decisions based on the ability to make more money or something like that, or it's not likely to cause people to get covered items or services that they don't actually need. So that's what's meant by posing a low risk of harm. All right, so that was the beneficiary inducement statute and a few of its exceptions. So now let's talk a little bit about the Stark Law, or the physician self-referral statute. And again, here we're talking about the federal, this is a federal law. And what the Stark Law says is that a physician cannot refer certain Medicare or Medicaid covered items or services that are called designated health services to an entity or a company that the physician has a financial relationship with. So that's why this is called a self-referral statute, because what its aim is it's trying to prevent or prohibit doctors from making referrals to companies that the physician makes money off of. So this is trying to make sure doctors make referring decisions based on the best interests of patients as opposed to the physician's likelihood or ability to make money off of that referral. Now, the Stark Law defines a financial relationship to be either an ownership interest in or a compensation arrangement with the entity to which the physician is referring these designated health services. So a lot of times people think that Stark only comes into play if a physician owns another business. But that's not true. If a physician has some other kind of, say, services agreement or arrangement with another company where the physician is getting paid money by this other company that it also sends referrals to, well, then you have to look at it under the Stark Law and see if it's okay. The list of designated health services, it contains, I don't know, 15 or so different specific items and services, and it does include things like durable medical equipment, enteral products, orthotics, outpatient prescription drugs, rehab therapy, just to name a few. Okay, so both the anti-kickback statute and the Stark Law, they can both act to prohibit a wide variety of activities. But because some of the activities that would technically violate either the anti-kickback statute or the Stark Law, because some of these things, they don't actually pose a great risk of fraud, waste, or abuse, the government has identified certain things that, while technically they would be violations, the government isn't actually worried about them. And so they have promulgated a number of safe harbors to the anti-kickback statute and exceptions to the Stark Law. I'm going to discuss some of the more commonly used and some of what I think are the more important safe harbors and exceptions. But before I do that, I think it's important to note that when we're talking about safe harbors to the anti-kickback statute, if an arrangement does not strictly satisfy all of the elements of one of the kickback statute safe harbor, that does not mean that the arrangement certainly violates the anti-kickback statute. Rather, if an arrangement does not satisfy all the elements of one of these safe harbors, it just means that the arrangement's facts and circumstances need to be evaluated on a case-by-case basis. This is different from the Stark Law's exceptions. Now, the anti-kickback statute safe harbors and the Stark Law's exceptions, they actually line up almost exactly. So in other words, a lot of the anti-kickback statute safe harbors, there's an exact corollary exception to the Stark Law. But in some cases, the exception to the Stark Law is a little bit easier to satisfy, because under Stark, you have to exactly satisfy all the elements of one of those exceptions. Now, some of the important safe harbors, they have elements that are hard to satisfy. So it's common that when I'm advising clients to implement certain practices into arrangements that will help them avoid kickback problems, a lot of times I'm not telling them you have to do these things because you have to exactly satisfy the safe harbor. I'm a lot of times telling clients, here's some things that you need to do because it will help you substantially comply with the safe harbor. And I think that's good enough to reduce your risk. So now let's talk about a couple of these safe harbors. The first one here is called the small investment interest safe harbor. We won't spend much time on this, and it has to do with investment interests by referral sources. It's actually kind of a tough safe harbor to satisfy. And it says that if a referral source owns stock in a company that the referral source sends Medicare or Medicaid patients to, the investment income that this referral source makes off of that company is not considered a kickback if certain requirements are met. Some of the notable requirements are that no more than 40% of this company that is receiving the referrals, no more than 40% of its ownership or stock can be owned by referral sources, and no more than 40% of the company's revenue can be attributable to referrals from those owners. And a lot of times those 40% limitations can be tough to satisfy. But this probably isn't one that you're going to bump into very much. So we'll move on to the space rental safe harbor. It's pretty common for a healthcare business to rent space from a referral source or vice versa. And in order for the money paid to a referral source who is a landlord, in order for that to enjoy the protection of this safe harbor, the lease needs to be in writing. It needs to be signed by both of the parties. It needs to specify the premises or the specific area that is covered by the lease. So it can't be something real general that just says, this company is renting just whatever space it needs in my office. It needs to be specific as to what is being rented. And it needs to specify if the lease is full-time or if it'll just cover various intervals. Sometimes maybe a physician might want to rent space from somebody it sends referrals to do appointments and things like that, but the physician isn't going to be there all the time. If that's the case, it should say what those intervals are when the physician has the right to use the space. In addition, the lease needs to be for a term of at least 1 year. The amount of rent that's going to be paid needs to be set in advance, so it can't fluctuate with, say, the revenue that gets generated under this, or the amount of referrals that are realized because of this relationship. The rent needs to be fixed in advance, and it needs to represent the fair market value of the space being rented. So it can't be tied to anything other than just what anybody else would have to pay in order to rent this space, whether or not the two parties were generating additional business for each other or not. The next safe harbor that you run into pretty often is actually quite similar to the space rental safe harbor, and that's the equipment rental safe harbor. And really the elements to these two are the same. The difference is just that one has to do with renting space. The other has to do with renting stuff. This next safe harbor is, I think, the most important one for you to understand. This is the one that I talk about the most often. The next one, which is the employee safe harbor, is the one I talk about probably the second most often. But this one is the personal services and management contract safe harbor. And it contains several elements that are actually similar to the space and equipment rental safe harbor, but some that are different. So this covers arrangements where a referral source is going to be providing other legitimate services to a company, like a DME provider. And the elements of this safe harbor, or at least the ones that I think are most important, are here on the next two slides. And this safe harbor requires a services agreement with a referral source to be in writing and signed by the parties. That's a common theme to these safe harbors. It requires that the services to be provided have to be specified. If the agreement is, if the services are going to be provided, if they are going to be given on a sporadic basis, which is almost always the case with these agreements, in order to exactly meet the requirements, it's supposed to specify the intervals or the different days and times that those services are provided. But often that is very, very difficult to do. So you almost never see that element satisfied. But that usually doesn't concern us lawyers a great deal, so long as these other important elements are satisfied, including that the agreement needs to be for at least a year. And here's kind of the kicker. The payment that's going to be made under one of these agreements, in order to substantially comply with this safe harbor, the compensation needs to be set in advance. And that means the aggregate compensation needs to be advanced. So in other words, the total dollar amount that's going to get paid to this referral source for whatever other legitimate services they're providing has to be set. So that doesn't mean that they're going to be paid $50 per service they provide. It means over the course of 1 year, they're going to be paid a total of, we'll say, $10,000 for whatever their services are. And a lot of times that can be tough to satisfy, but it's important in order to reduce risk and enjoy protection. And the payment that is going to be paid, again, it needs to be the fair market value for the legitimate services that are providing. So even if this referral source is going to be providing legitimate services, let's say you have some kind of, we'll say a consignment closet or something like that with a physician where you put your DME, and the physician's office is going to provide setup services to patients on your behalf. Well, that could all be okay, but if you are grossly overpaying for those setup services, the government has said, well, we think that looks like a disguised kickback, where there is some legitimate services you're providing, but if you're not paying the fair market value for those legitimate services and you're just overpaying, all you're doing is disguising the payments that are in exchange for the referrals into this agreement. So you're inducing them to send referrals by overpaying for the setup services in my example. Hopefully that makes sense. The next important safe harbor is for employees. And this is a very frequently relied upon safe harbor. The first critical consideration under this safe harbor is whether a person is actually a bona fide employee. You can see that word bolded here on this slide. And determining whether a person is a bona fide employee means more than just looking at whether the person is on a company's payroll as a W-2 employee. The way you have to analyze this is by looking at the IRS actually has a multi-factor test that it uses to determine whether a person is an employee of a company or an independent contractor. These factors that the IRS test looks at really have to do with the amount of control that a company exercises over an individual. And there isn't a bright line test that if a person, if 5 of these factors are met, then a person is a bona fide employee. But the more control that a company exercises over a person, if they have to be working certain hours and come to trainings and make reports, all those kinds of things, those contribute to determining someone is actually a bona fide employee. Whereas the more independent somebody is, the less it looks like they're a bona fide employee. But amounts paid to bona fide employees for furnishing covered items and services, well, they are covered by a safe harbor. And this is often important because companies like to pay commissions to salespeople. And so if we've got bona fide employees, then that's when commissions can be safe. Whereas there might be risk in paying commissions to someone who might not be a bona fide employee. So those are the most common safe harbors and exceptions that we've just gone over. Now we'll go over a couple other things that are also important to understand. And the Department of Health and Human Services is the agency under which CMS falls, or the Centers for Medicare and Medicaid Services. And I mentioned earlier that the enforcement wing of this agency is called the Office of Inspector General, or OIG. The OIG has a process by which anybody can submit information about either an actual or a proposed arrangement that might implicate the anti-kickback statute. And somebody can submit information about an arrangement and ask the OIG to give them an opinion about whether or not this arrangement violates the anti-kickback statute. When these requests are submitted, the OIG will ask a bunch of questions and you give them information. And then when they're satisfied that they have enough information, they'll perform their analysis and issue an advisory opinion. And these advisory opinions are published and anybody can look at them and read them. And while technically only the parties named in that advisory opinion and who submitted and paid for the advisory opinion can actually rely on it, they are an important and very helpful tool to everybody else, because reading them helps you understand how the OIG interprets the anti-kickback statute and how it applies the anti-kickback statute and its safe harbors to different kinds of facts that you might encounter, different kinds of arrangements that might be very common. So these things are very helpful, and they're on the OIG's website and they're searchable. And I highly recommend that if you're ever in a situation where you think you might be dealing with something that implicates the anti-kickback statute, you can go there and search advisory opinions for key terms, and you might read a couple and see what they have to say and see if they're helpful. Another type of guidance that the OIG issues is special fraud alerts and special advisory bulletins. Again, these things are available on the OIG's website, and where advisory opinions are they address specific arrangements or proposed arrangements. Special fraud alerts and advisory bulletins, they offer more general guidance that's not specific to certain parties but they normally relate to trends that the OIG sees in the industry and that it finds troubling. Specific to DME suppliers, there's a 2003 special advisory bulletin on contractual joint ventures with referral sources. There's a 2010 special fraud alert on telemarketing done by DME suppliers. So there are other types of guidance that the OIG has issued that are specific to our industry. Okay. Up to now, we've really been discussing just the federal laws, the federal anti-kickback statute, the federal Stark statute, and those statutes apply to remuneration given to sources of referrals of patients who are covered only by federal healthcare programs. But what about remuneration that's provided to sources of strictly commercially insured or cash-paying customers? Well, there, the federal anti-kickback statute doesn't apply, but the analysis isn't done. All states have some form of their own anti-kickback statute. However, each state's anti-kickback statute varies in its scope and application. Many states have an anti-kickback statute that only applies to arrangements that involve referrals of patients who are covered by that state's Medicaid program. But several states, it's the minority of states, but there are several that have a much more broadly applicable anti-kickback statute that in some cases will apply to remuneration given to a source of commercially insured or even cash-paying patients. Sometimes these state laws are buried in really unexpected places. Sometimes they're worded in ways that are even less clear than your standard legalese, which is already often a bunch of gobbledygook to begin with. So it can be really important to get help when you're trying to figure out if a state anti-kickback statute might apply to a situation that you're dealing with. This statute has to do with a law that's a little bit different from other types of fraud and abuse laws that we've discussed up to this point, but it's a law that I think is worth talking about quickly. I'll speed up here just a little because I want to get through some specific examples and still give you a few minutes to ask questions and get you out by the end of the hour. So this slide is titled the Anti-solicitation statute, but sometimes you might hear this law referred to as the telephone solicitation statute, and there's actually a companion regulation that happens to be one of the 30 supplier standards that Medicare requires all DME suppliers to follow, and that's called Supplier Standard 11. So this, what I'm talking about now, can has many different names, but it has to do with the circumstances in which a DME supplier can call a Medicare patient on the phone. What it all boils down to is essentially this: a DME supplier that is enrolled with Medicare should not be calling a Medicare patient on the telephone unless either one, the patient has given the supplier written permission to call them, two, the DME supplier has sold something that is covered by Medicare to that patient in the past, anytime in the past, and the supplier is calling the patient about that same item. Or number three, the supplier has sold something that's covered by Medicare to the patient in the past 15 months. And if they've sold something covered by Medicare in the past 15 months to this patient, then they can call them about any other Medicare item. So those are the three. You don't have to satisfy all three. If one of those three criteria is met, then a Medicare enrolled DME supplier can call a Medicare patient on the phone. And that's important to understand because DME suppliers have come under scrutiny from the government for what the government thinks is abusive telemarketing practices. And so it's important to know when you can call someone and when you cannot. All right, so now let's get to a couple of examples. You've got a baseline understanding of some of these fraud and abuse laws. Now let's talk about common questions or issues or arrangements that I see. For some of you listening to this, a few of these specific example arrangements I'm going to go over might not be things that you're likely to ever actually encounter or deal with. But even if that's the case, I still think that's okay, and it's helpful to go through these with you so that you can hear about real factual scenarios that can implicate the laws we've been discussing. And hearing about actual scenarios that might implicate a law like the anti-kickback statute, even if it's not a scenario you're going to actually see, hearing about it and knowing why it implicates those laws can still help you recognize when you might need to be concerned or ask more questions in the scenarios that you do actually deal with down the road. So the first example we'll start with is medical directorships. It's very common for businesses in the healthcare industry to have a medical director. This is somebody who can do things like periodic reviews of company policies and procedures that deal with provision of healthcare to patients. Medical directors can provide consultation or training on patient care or other related issues. Typically, though, a medical director is a physician and they don't work for free. So a company normally will be paying money to a medical director. And it only makes sense for a company to ask a physician who the company has an existing relationship with to act in this role as a medical director. So normally the medical director is going to be a physician who is also a patient referral source. Now, if we have a company paying money to a physician who is a referral source, those are the two critical components to any arrangement that should trigger in your mind the need to analyze the arrangement under the anti-kickback statute, that being referrals and then money going back to the source of referral. So the terms of a medical director agreement, essentially they need to substantially comply with that personal services and management contract safe harbor that we went over. The agreement should be in writing for a year. The patient should actually be providing substantive services. It can't just be a sham where you list services in a contract that they don't actually provide, and the compensation that is being paid should be fixed for a year in advance and should represent the fair market value of the services they're actually providing. Another important thing is that a company normally doesn't need more than one medical director. Sometimes they do, but a company shouldn't have more medical directors than it reasonably needs. All right. We are getting a little short on time, so what I'm going to do is skip to an agreement that I know that we need to talk about here, or an arrangement, not an agreement. And that is, forgive me, providing free or replacement products. So many times suppliers, DME suppliers or other kinds of providers, they can offer customers or potential customers free items or discounted items or services. And sometimes this doesn't have to be items that are actually covered by Medicare or insurance. Sometimes it can just be things that the business's target audience might be interested. For instance, I've seen commercials on television by diabetic testing supply companies, where they'll say, you know, if you call in now, we'll give you a free cookbook with recipes that are are helpful for diabetics. So that free cookbook is an example of something that's not going to be covered by insurance, but is something free being given to a patient. But this could also be items that are covered by insurance. Maybe a supplier is offering a free initial supply of disposable items that will be used with an underlying device. All right, so these are common arrangements that we see. Now, as we talked about before, there is this beneficiary inducement statute that says you can't give away free stuff in order to induce a patient to choose you as their supplier. But people do it all the time. So as we talked about before, there is an exception for things that have a nominal value. It's okay to give a patient anything that by itself has a retail value of $15 or less. That's okay. So if you want to give, a free week's worth of product, and that a week worth of some kind of disposable supply or something like that is worth $15 or less, well, then that's covered by the nominal value exception. Now, can you give away a free week's worth of items to the same patient 15 times? Well, probably not. Under the nominal value exception anyway, you have to look at all the free stuff you've given to any individual patient over the course of a year. And if the value of those individual items add up to more than $75, even if the individual items were worth 15 bucks or less, well, then you're not covered by that exception. But doing it once or twice, that's okay under this nominal value exception. So free products or services that don't fit within the nominal value exceptions limits, they don't necessarily violate the beneficiary inducement statute, though. If we talked, as we talked about before, if you're giving away something and that something, it poses a low risk to the Medicare or Medicaid programs, you're not giving it away because it's likely to cause patients to get a whole bunch more covered stuff that they don't actually need, and it just promotes access to care for this patient. It's maybe somebody was given something that doesn't work well for them, and so you give them something else for free that does work for them. Maybe that promotes access to care. But the point I'm making is that even if those $15 and $75 limits aren't satisfied, there might be other arguments or reasons that justify other giveaways or things like that. Now, the last thing that I was going to cover essentially talks about the ways that are common for businesses to get in trouble or come under scrutiny. And normally, the way healthcare companies wind up in the crosshairs of the government is by a whistleblower going to the government and bringing some kind of whistleblower lawsuit. And the government takes these things very seriously. They're also called qui tam, or some people call them qui tam lawsuits. And typically what they say is that we think this company did something bad, like they violated the anti-kickback statute. And so all of the claims and the reimbursement they got from Medicare that resulted from the violations of that kickback statute, they are a violation of what's called the False Claims Act. And so government, we think that you should go after this company. There are other ways, though. Often the government will sift through data. I think I have a slide here that talks about how the government will monitor trends in claim submissions to find patterns that might indicate fraud as well. So there are different ways for these things to be identified. I had hoped to leave maybe about 10 minutes, and I'm glad to stay as long as we can need to, as long as there's questions. But if there are any questions, I don't know if you have access to keyboard to type in questions, but in the webinar module towards the bottom, there is a box to type in questions. And yeah, it looks like we've got one. And if there's more, I'm glad to read those and go over them. It looks like this just says that you don't have a medical director, which is fine. If you ever do in the future, you'll know what to look for in those. But if there are any other questions, you can feel free to type them in. If there aren't questions or you think of questions later, feel free to email me. My contact information is here on this last slide, as well as I believe on the first slide. I'm glad to email or have another call later. But with that, that concludes my presentation. And I appreciate you listening to me. And it was my pleasure speaking to you today. And hopefully we'll talk again soon.